Serious accidents or life-changing physical malady can happen to anyone at any time. I personally have two friends who seemed totally healthy and are now suffering from MS, and one is severe. What are the legal and financial implications, especially if there should be a need for Medi-Cal?
Well, if you have a need for Medi-Cal, there are certain standards that you have to meet in order to qualify for Medi-Cal. Otherwise, they insist that you pay out of your pocket until you're broke. In order to qualify for Medi-Cal, you're supposed to have no more than $2,000 in assets, and your income should be no more than $35 a month, which means that most people will wind up broke before they can get to that point. There are certain assets that state will exempt, but that's something that the person doesn't know about and know how to plan for strategically to make sure that they don't lose everything that they've developed. So,
being a realtor, I would be remiss not to ask a real estate specific question. What are the implications of an heir who inherits a property by will only and then wants to sell it versus acquiring and selling it under the umbrella of a living trust? Is there a difference?
There isn't a difference for sure. If you have a will, you are required to go through the probate court process. You must go through the probate court process. If you've done no planning at all and your estate is over $150,000, you must go through the probate court process. The only way that you avoid probate court is by having a trust. That's it. If you have to go through the probate court process, as I mentioned before, there's going to be an attorney who's going to get a percentage of that estate. There's going to be an administrator or an executor, if there's a will, who gets a percentage of the estate, and they get the same percentage. In addition to that, each of them will be able to charge for extraordinary services in connection with the sale of the real estate at an hourly rate basis. Most attorneys are going to be charging anywhere from $250 to $500 an hour against that asset. You don't want to have real estate and go through probate. That's why I always suggest to anyone who owns real estate that you not have a will. It does not protect you. It in fact puts you squarely in the probate court process and all the time and exposure that is entailed in that. If you have a trust, you can transfer that property without the involvement of any court system at all. The trustee is usually empowered to sell that property, pick the realtor that they want, sell the property, get the proceeds, and distribute the monies to the beneficiaries.
Attorney Hayes, I would like to thank you for shedding so much light on such a complex topic in a way that even the layman can get it. I think we learned just enough to know how much we really don't know, which means that hopefully we can do this again to talk exclusively about some of the specific components such as living trusts, wills, power of attorney, and more. In the meantime, I'm sure there are many who can benefit from your expertise right now. How can someone get in touch with your office?
Well, you can always go to our website, which is pretty easy to remember. It's losangelestrustlaw.com. Our phone number is 626-403-2292, and call us at any time. We also do seminars, as I mentioned, and we do them for organizations throughout Los Angeles and San Bernardino County. We do them for churches. We do them for insurance agencies, realtors, banks, anytime. Just give us a call and we'll be free to talk.